Good evening, Mr. Speaker.
Good evening.
A few questions through you, Mr. Speaker, if I may.
You may proceed.
Thank you, Mr. Speaker. The first question through you, Mr. Speaker, is in regards to the community benefit agreement, which is placed in this bill. Now, I understand that under current law, that applicants may enter into an agreement with municipalities, but my understanding is that that is now changing under this bill, and that if a community has more than 5 certain facilities, affected facilities under the definition of this bill, that it's now required. Is that true? And if so, if the good proponent could expand on what needs to be done with that provision. Through you, Mr. Speaker.
Thank you, Representative. Representative D'Amico.
Yes, Mr. Speaker. Yes, the gentleman is correct. As he stated, as I earlier stated, if a municipality has 5 or more of these affecting facilities, then a subsequent proposal to permit another of such facility in the municipality would require a community environmental benefit agreement between the proponent of the facility and the municipality. Through you, Mr. Speaker.
Thank you. Representative Harding.
Thank you, Mr. Speaker. And through you, if I can expand on that to the good proponent of the bill. The one question that I have about that is that it looks that this, as I said, applies to communities that have 5 or more of these affected facilities. But does this only apply, though, the entire bill in its entirety, including this provision, to only communities that are considered environmental justice communities? Or does this also include communities that may not be considered environmental justice communities, but may have 5 or more of these facilities? Through you, Mr. Speaker.
Representative D'Amico.
Yeah, thank you, Mr. Speaker. My understanding is that this bill only applies, as the gentleman stated, only applies to environmental justice communities. Through you.
Representative Harding.
Thank you, Mr. Speaker. So more specifically, if I may, then expanding on that point, so the provision that mandates an agreement to be made between the municipality and the applicant is only for communities that are environmental justice communities that also have 5 or more of these facilities. Is that true? Through you, Mr. Speaker.
Representative D'Amico.
Through you, Mr. Speaker. That is my understanding, yes.
Representative Harding.
Thank you, Mr. Speaker. And through you, Mr. Speaker, expanding on the community agreement, my question is, what occurs if the municipality and the applicant can't come to an agreement? Let's say the municipality has certain requests that the applicant may or may not want to meet, and the two entities can't come to an agreement. Does that automatically nullify the application then? And is it denied absent an agreement? If the good proponent could expand on that. Through you, Mr. Speaker.
Representative D'Amico.
Through you, Mr. Speaker, my understanding is that based on the provisions of this bill, that this agreement shall be entered into between the municipality and the proposer of the facility, and I believe the gentleman is correct that if no such agreement can be reached, then the facility cannot be cited. Through you.
Representative Harding.
Thank you, Mr. Speaker. And just commenting on the bill, I think there are some positive aspects of this bill. One of them is a slight change in regards to notification, which now instead of permitting an applicant to notify residents, it now mandates certain requirements such as posting signs. The one question, if I may, through you, Mr. Speaker, is what is considered to be a reasonably visible sign? Is it a billboard? Is it signs in a community? Where exactly do these signs need to be placed? Through you, Mr. Speaker.
Representative D'Amico.
Yes, thank you, Mr. Speaker. I'm looking at line 73. Which is existing language already in statute that refers to posting a reasonably visible sign, printed in English, and then on line 75, posting a reasonably visible sign printed in all languages spoken by at least 20% of the population that reside within a half-mile radius of the proposed or existing facility. So that's already been in statute for about 10 years. So Nothing here is changing with regards to that specific issue. Through you, Mr. Speaker.
Representative Harding.
Thank you, Mr. Speaker, and I appreciate the clarification from the proponent in regards to that measure. Adding to that, I think I think that's a reasonable step in regards to the notification process, so I do support that initiative. I also think it's good that the community agreements that we were discussing before would be now consider some of the health effects of living in and around one of these facilities, which isn't previously one of the measures that would have been considered. It previously was just environmental measures and traffic measures and noise measures. This now adds in considering measures in regards to the health of the individuals surrounding the community. And for that reason, I'll be supporting the measure. But I do believe that the aspect or provision of the bill that mandates that a municipality and an applicant come to an agreement in instances where there's 5 or more of these facilities really could prevent a significant barrier between these affected facilities deciding to invest in these communities. And for that reason, I do believe there is some objection from some of my colleagues in that regard. Overall, I think it's a reasonable step to addressing some significant health issues that I think are positive to be addressed, so I'll be supporting it. But I do have some concerns, and I know some of my colleagues have some concerns regarding measures that may prevent investment in regards to some of these facilities and in regards to some of these communities. So I look forward to the further debate on this. I want to thank the proponent for bringing the bill out, and thank you, Mr. Speaker.